Hello and welcome to the LLG vlog. You're with me, Dennis Hall, LLG's Bulletin Editor, and as usual, Helen Bennett, LLG's Executive Director of Policy and Governance. Great to see you again, Helen.
Hi, Dennis.
Well, we are back on camera and in front of the microphone once again after our summer break. Helen and I are refreshed, energized, sparkling, well, at least Helen is, and we're both ready to update our members with what's been happening in the local government legal sector over the summer, and indeed since the last bulletin was published. And this is our selection of the things that you may have missed.
Yeah, because we've been following the latest announcements from government and we've spotted some interesting articles on topics, haven't we? The members will definitely want to know about that. And we'll round off with some commentary, I think, on some interesting court cases that caught our attention. So I think we have to begin with local government reorganisation, Dennis.
Indeed.
Definitely. So the Ministry of Housing, Communities and Local Government has published an explanatory note on regulations for the sale and purchase of significant assets, which it says includes IT procurement in advance of the reorganisation.
Indeed, and it states that the government intends to issue directions under the Local Government and Public Involvement in Health Act 2007, requiring written consent from the successor councils for contracts of more than £1 million in capital and for entering into contracts of more than £100,000 for non-capital based on whole life costs. Now, this is based on previous precedents and aimed at ensuring new agreements will be in the best interest of the new councils. Now, it's interesting. That's an important piece of information for local government, local authorities in LGR areas, and clearly it is a restriction on potential spending that they may be contemplating. But I'll move on. There's been a press release as well from the Education Department. The government intends to speed up reforms to protect children from harm, and government has made a major announcement concerning reform to protect children. Vulnerable children are to be better protected from harm after the government speeds up its children's social care reforms that prioritise prevention through its plan for change. An extra £18 million will be spent now on rolling out early intervention child protection reforms for councils in England to stop families from reaching crisis by strengthening leadership and speed up delivery. So it's a key announcement there.
Yeah, absolutely. And welcome, I think. And the reforms, I believe, also include the rollout of family group decision-making, which is an approach to involve extended family members in helping keep children at home rather than care. And thousands more family health workers have been pledged to provide early support for families experiencing challenges such as substance abuse or mental health. I should just say, actually, we've got some changes. In the government, we have a new Secretary of State, and we now have a minister, and Jim McMahon has, been replaced essentially. So, but I haven't actually checked what's out yet in terms of the news coverage in relation to that. So members will have to pick that up themselves. I'm sure they've already seen who the new minister is. So
indeed, and all the detail, Helen, will be in the next bulletin coming out this Friday.
That's right. Yeah. Well, let's turn to some interesting articles that have appeared over the summer. The new one, of course, that was covered in the Local Government Lawyer was something that LLG played a part in with CIPFA and Solace. That's the news that we published a new guide, and it was very much welcomed by the sector on the roles and responsibilities of the 3 Golden Triangle officers, basically in a bid to improve understanding of their duties, because I think there's definitely confusion around the monitoring officer's role, and it's even more crucial that it comes out now because that's a time of major change for councils. So we did publish it jointly with Solace and CIPFA, as I've said. It's called the Golden Triangle Governance Roles and Responsibilities, and it provides a summary of each role: Head of Paid Service, MO, Section 151, and a really in-depth list of their key responsibilities. And it includes commentaries on the duties as well. So it also, I should add, points readers to other useful resources, such as the Code of Practice on Good Governance for Statutory Officers that we published back in 2024, 3 of us. So I would urge people to read it. It's relevant to everybody if you work in a council.
And describing the document, the three organisations, excuse me, said the short joint guide provides a concise, structured and clear outline of the three Golden Triangle officer roles to help maximise transparency, clarity and understanding around those professional duties, as you say, Helen, at a time of major change within local government. And of course, all of the detail will be in Bulletin 29, and monitoring officers and all governance practitioners will be especially interested.
Yeah.
Now, I turn to another item that appeared in the local government lawyer about council legal workloads rising while job satisfaction remains high. And this was the survey by LGL about the legal department of the future. And this came out during the summer. And 9 in 10 heads of legal now predict that their legal department's workload is set to increase in the foreseeable future, with more than half believing the amount of work will increase significantly. And this is the research from the local government lawyer. The findings come in this latest survey, which gathered responses from 83 heads of legal and more than 350 local government legal professionals covering recruitment, rising workload, technology usage, and home working.
Yeah, it's a good input for a survey, actually, so we should pay attention to it. So according to the survey, 92% of heads of legal expect their legal workload to increase over the next 12 months, with 56% anticipating a significant rise. And notably, not a single respondent predicted a decrease in demand, Dennis. It does seem, though, that every time these surveys come out, everyone's always predicting more workload. But I think that's the reality. That's been the case for a long time. So the survey did cover staff of all levels, from trainees to principal lawyers and above. It showed that, pleasingly, job satisfaction is really high, Dennis. 84% recommending local government law as a career. I certainly always would. It's thoroughly rewarding, interesting, and you've got the support of your colleagues. So that's a positive thing that we can take from all of this. Another item of interest, this is to do with the land registry, who's inviting deeds signed with witness-free electronic signatures. So do you remember during COVID, we actually took a deep look at legal documents, especially conveyancing and land registry forms.
Indeed, I remember doing some research on this myself, Helen. It was a big issue, and I had lots of questions and queries from our membership about this at the time, if you remember.
It was a really big issue. And we were looking to see whether at the time electronic signatures were permissible. I know as well in probate and wills, there were huge difficulties, and the law seemed to change fairly quickly in that regard. In early August, this was back in the news of the Law Society Gazette article, it announced that HM Land Registry had taken what it described as a decisive step towards all digital conveyancing, by inviting solicitors and others to start submitting applications that include documents authenticated with so-called qualified electronic signatures.
Indeed. And the move follows several years of investigations of the technology for witness-free signatures. Qualified electronic signatures are digital signatures complying with the 2014 EU regulations adopted in the UK under what is known as the eIDAS regulation. They are signatures authenticated by third-party trusted service providers approved by the Information Commissioner's Office. All interesting stuff.
Yeah, it's got to be the way. Sorry, Dennis, I was just going to say it's got to be the way forward, hasn't it?
Yeah, indeed. It's going to come forward in a much bigger way, particularly with the introduction of AI techniques now. Next item in the local government lawyer was entitled High Court Sets November Hearing Date for the Judicial Review of Guidance Issued by the Equalities Watchdog. Now, this was earlier in August. The High Court is to consider in November a judicial review challenge over the Equality and Human Rights Commission guidance on trans people's use of toilets at work and in other services following the Supreme Court's decision in the case of For Women Scotland and Scottish ministers, again held in something that we've looked at in some detail. In a High Court hearing in early August, Mr. Justice Swift gave directions for the claim to proceed to what is termed a rolled-up hearing.
Yeah, I understand that the claimants allege that the commissioners interim update on the practical implications of the UK Supreme Court judgment, which was published shortly after this Supreme Court case, actually mistakes the law as their position, and further that it encourages employers and service providers to breach their legal duties under the Equality Act, Human Rights Act, and the Gender Recognition Act. I should say that we do cover commentary by the EHRC in relation to single-sex spaces and policies relating to those in the podcast. So people, members definitely should listen to that.
Yeah, interesting stuff. Let's turn now to a sort of case roundup for the summer. Those cases that we think are the highlights from the case listings in late July and August. And one that will be of interest to all licensing lawyers concerning taxis is the case of Delta Merseyside Limited and Uber Britannia Limited. Uber are always in court these days, it seems, and challenging various aspects of licensing law. And here's another example. The Supreme Court dismissed an appeal by Uber over whether the regulatory scheme for the provision of private hire vehicles, PHVs, outside London and Plymouth makes it unlawful for an operator to accept a booking other than by entering into an immediate contract for hire with the passenger as principal to provide the journey which is the subject of the booking. The Delta case concerned the correct interpretation of the statutory regime regulating the provision of PHVs, which, as distinct from traditional taxis, cannot ply for hire on the streets, but are booked in advance through an operator.
Yeah, the Supreme Court's press summary noted that Part 2 of the Local Government Miscellaneous Provisions Act, that's the 76 Act, regulates the PHV trade outside London and Plymouth by imposing what they refer to as a triple licensing law. In other words, operator, driver, and vehicle must each be licensed by the relevant authorities. That's quite interesting. Let's now take a look at a case involving a school and the use of isolation rooms. So that's the King on the applications of EBB, LAX, and LUN, and Gorse Academies Trust. So that's the school in question. So I think education lawyers definitely need to pay attention to this. So the High Court has upheld the use of isolation rooms by schools in England. So this is pertinent to England. Which dashed the hopes of campaigners who argue that they're stressful and stigmatizing for pupils. The use of isolation rooms is highly controversial. So the judge turned down an application for a judicial review of the use at secondary schools in Leeds. This was in Leeds, noting that there are few alternatives other than suspension, and that the behaviour in 2 of 3 cases submitted showed signs of improvement. So, yeah.
Yeah, it's a highly controversial thing, this, and there've been quite a few articles since this case, Helen. So it's clearly a matter of general discussion, and people are querying the use of these methods, I think. And the use of the booths has become a flashpoint within education, with an increasing number of schools using them to manage pupils with complex behaviour. After budget cuts and shrinking local authority services had reduced the external support available. I think we'll hear more about this in the coming months, frankly.
We definitely will, because of the proposals the government we're expecting in the September around changes to SEND.
Yeah, definitely. Now, another case that caught our attention was concerning judicial appointments. We've done a number of articles and reported things on this over the years, and the question of fairness and issues of discrimination. And this was the case of the Crown and the Judicial Appointments Commission. It's about the fairness, as I say, in the judicial appointments process, and will be of general interest to our members, because a judge aggrieved at being denied promotion has had a partial victory in the Court of Appeal in a challenge to the secretive judicial appointment processes. I think we've always suspected, Helen, that these things happen that way. But District Judge Katie Thomas, who sits at Walsall County Court, brought the case against the Judicial Appointments Commission, the JAC, to which she had applied in May 2021 to become a circuit judge in both crime and civil cases. After being interviewed, Judge Thomas was initially told she was deemed selectable in 2 categories of practice, but then was later told she was not appointable in either case because the JAC's Selection and Character Committee had reduced her grade in the working and communicating with others category from C to D.
Well, the court didn't quash the Commission's decision in Judge Thomas's specific case, largely due to insufficient information and late disclosure, although I think she probably feels truly vindicated.
Yeah.
Because the court upheld her central arguments about the lack of fairness and transparency in the Commission's consultation process. So I can't say I'm particularly surprised, but that's my personal view on that, Dennis.
Yeah.
Now, let's turn to Epping Forest. The Epping Forest asylum case has been in the news a lot. It's been widely reported, and it now has been successfully appealed. We do touch on it in the podcast.
We do. But if I can chip in first on this, the Court of Appeal, this is the main thing, the Court of Appeal has allowed an appeal against the interim injunction granted by Epping, blocking the use of the Bell Hotel in its area to accommodate asylum seekers pending a full hearing, of course. There'll have to be a full hearing, and that will be in October this year. Now, the judge's approach to the balance of convenience exercise and a range of public interest factors has been seriously flawed in principle, according to the judgment, and in a number of important respects. And in particular, it was desirable to preserve, the court said, the status quo and undesirable to incentivize protests.
I mean, it's highly controversial. We keep saying that. It's true, though. I mean, councils across England are poised at the moment to contemplate legal action to remove asylum seekers from their hotels in their areas as a result of this case. Further court cases absolutely must be anticipated because it follows the High Court granting a district council a temporary injunction to blocking asylum seekers from lodging at the Bell Hotel in Epping, Essex. The appeal proceedings have since reversed that decision, but that's not the end of the story by any means, because there's a further hearing.
And it's obvious why, because all 10 councils controlled by Reform UK say that they will do everything in their power to follow Epping's original lead. And indeed, Nigel Farage said this earlier in the summer. Now, there is an update on this story, came in last Friday. Epping Council have announced that they will make a direct appeal to the Supreme Court to overturn the Court of Appeal's decision, even though an earlier permission request was refused. Of course, there'll be much more of this, and it'll be widely reported, and we will include more in the Grapevine podcast. Sorry, we have done, and that one accompanies Bulletin 29.
Yeah, that's right. Well, I think before we wrap up, we've covered quite a bit. I think there's a few more remaining key headlines. Obviously, all the details in Bulletin 29, as you've said, but let me just take a quick look at the Wicker Media case. So this case marks one of the first significant legal challenges to the Online Safety Act. That's the 2023 Act. That's a statute that's already provoked widespread debate amongst service providers, civil society and regulators.
Right, my turn. This is a case that will be of interest to housing lawyers, so watch out. There's this case of Fairtree, I think I've pronounced it correctly, or Fairtree, and the Vale of White Horse District Council, which clarifies the law concerning asylum seekers and the extent of assistance they're legally entitled to under the homelessness guidance. That'll be interesting.
Helpful, I think. And watch out too for the local government lawyer article, which talks about London councils urging the government to reconsider key elements of plans to reform council funding, which is in response to the Fair Funding Review 2.0 consultation, and which closed incidentally during August.
Yeah. And we noted before the weekend's business that Deputy Prime Minister Angela Rayner was in the news already before her departure for other reasons. Her now former department faces a legal challenge after she overruled a local council to approve a hyperscale data centre on Greenbelt land next to the M25 in Buckinghamshire.
And I think to flag from me, there's a really important report from Grant Thornton reviewing a number of recent auditors' reports. So looking at all of them to discover the key lessons learned. So with the establishment of the new audit body, I think everyone needs to really get a grip on the failings in relation to audit and how they apply to their local authority. So you can find that via the bulletin as well.
And finally, from me, there's a link to news on the Centre for Governance and Scrutiny website. They say that the plans in the English Devolution and Community Empowerment Bill, which we've looked at, those parts that particularly expand mayoral powers and duties, they say must go hand in hand with stronger expectations on accountability. They seem to think that the proposals are very wanting on questions of having overview and scrutiny arrangements. So it's quite an interesting topic there to end on.
Absolutely. Well, that was quite a lot of detail in there. I do hope members found it useful. Thanks for coming along and sharing your time with me, Dennis.
No problem.
And always a pleasure. That's it for the vlog. We hope the summer roundup has been useful. And as usual, you'll find all the detail. We've said it a lot during the vlog. Bulletin 29. It's all packed in there because there's a lot to catch up.
That's the one.
That's the one.